taught them that. The question of allegation is unnecessary because they know it's an allegation. What is important is for you to give the grounds on which you think your client is housed. Please do not say that in court. In the days of Gapas Berewa, what's his name, Guy Baba, you will not make an application and ask the court to say, my lord, consider it's an allegation. Of course it is an allegation. Please, it is wrong, it is very inopportune for anybody to say that in court. I get really upset to hear that. Look at Hatchball. You will never see a thing like that. Secondly, when you are making an application for bail, just don't rush to Section 79 of the Criminal Procedure Act. Start today the foundation. Section 16 of the Constitution gives you a right to bail. Look at 23(4), the presumption of innocence, before you come to 79. Bail is a right, it is not a privilege. I also get very upset when I see some lawyers strenuously begging, although really I don't blame them, but in fact, the onus is on the prosecution. Oh my God. Sorry. When you have made the necessary application, the onus is on the prosecution to show the court why your client should not be given bail. It is not the job of the defense. I said on television the other day, it is not a privilege. It is a right. Section 16 of the Constitution, 23(4), and 79 of the Criminal Procedure Act. You cannot just go on 79 of the Criminal Procedure. As I said, I'm sorry, forgive me, because I only taught evidence at the law school for 20 years. But I know that to do that criminal procedure, just don't rush to 79. You have to give the court the impression that everybody is entitled to bail, except if you're charged with murder, treason, aggravated robbery, or mutiny. Those offenses are clear, you cannot get bail. And the new criminal procedure bill, which is now being, I think they're just about to enact it, is better than the criminal procedure, not so much. You'll see the conditions. So bail is important. In fact, it's a whole gamut for itself. In England, they teach you how to apply for bail. It's a whole section in itself, but we take it for granted. Secondly, I think we have to talk to some of our colleagues at the bench, not you, my lord. They grant excessive bail. There are times some of the bail conditions are excessive. If you know the condition is excessive, you have the right to go to the High Court because it amounts to no bail at all. It amounts to no bail. You must not grant excessive bail. You're actually locking up people at the correctional center. I just want to make a few comments. The other area I want to make comment on is the question of submission of no case to answer. A submission of no case to answer inside is based on Lord Parker's practice direction of 1962. Take that down because I don't know who taught you criminal procedure. In Sierra, as far as I know, up till today, and I've been here for 43 years as a lawyer, the no-case submission is based on the practice direction of Lord Parker of 1962, which will give you the two conditions under it. But as I said, my lord, I might be wrong, I don't know, but I'm sure you agree with me that it is Lord Parker's practice direction, which is the correct version of the law. Or the submission of no case, you cannot go beyond that. I have had a few things, but as I said, I keep quiet and sit down because some senior lawyers also have not held the court. But anybody who's been through our law school, anybody who has studied in England or overseas will tell you that in the Commonwealth countries, for the time being, a submission of no case is based on the Parker's practice direction of 1962. It was a practice direction and it's still today. All right, let me leave the criminal law because we have the experts, Justice Cam, Mr. Ivan. Let's come to civil. Civil cases to me about the most difficult area of the law. Criminal cases are not easy, but what you have to do in civil cases are much more technical and much more analytical. I think the first thing you have to do when somebody comes to you is to know that this person has a cause of action. Many times I see my friends, my colleagues, they rush to court and issue a writ. The point is, you've issued a writ, but has it disclosed the cause of action? That's the first thing. Has the person who comes to you got a cause of action? Is it something you can issue a writ for? Also, is it something you have to go to court by summons instead of issuing a writ? The chamber matter, you know that all chamber matters you must go by summons. There is no exception. Or is it by originating summons? Or is it by originating notice of motion? Or in fact, is it by petition? Cases concerning divorce or company matters. You must be grounded in how you begin a case. A lot of cases are just, don't say fear of time. They're really a waste of time. Because in some countries, before you even go to trial, when you get to the stage of summons for direction, in England they have the master and the external handles that. They would have decided there and then whether the case is worth going forward. They would not even allow you to proceed with the case when there is no cause of action. Or in fact, all preliminary matters would have been decided there and then. And I think, as I said, one of the good things about this new criminal procedure bill and our new civil procedure, 207 rules, is that now at summons for directions, you can deal with all preliminary matters. So that is a crucial stage, whether the case should proceed. If the writ does not disclose the cause of action, move the court to strike it out. Don't allow it to proceed. Some people say, well, Mr. Gabriel, let them proceed. At the end of the day, I will get more costs. No. That is bad practice. Move the court by motion or summons to strike out the writ because it discloses no cause of action. Also, if the defense that has been filed does not disclose the defense in law or is a sham, go to court to strike out the defense. So that there are times when you do not have to go to a full trial. Just by the preliminary stages, I'm sorry, you take time to get, but these are the things we learned over the years in practice. Because people think there is a writ, I'm going to enter appearance, there is a defense. No, you don't even have to go to that. In fact, another thing we do not do now, which we used to do, when you look at the pleadings, you can see whether there is a point of law which, when determined by the court, can dispose of the action completely. Let's take, for example, it's a matter of limitation of time. If this person has sued out of time, all you have to do is to go to the court to say that the court has no jurisdiction to entertain the matter because the matter is out of time. Limitation Act of 1961. You show the section and ask the court that they should not proceed this matter. The authority on that is Freeman versus Luke. It's a classic case which says that it's a court of appeal case. I can't remember the decision now. But if you have a point of law which disposes of the matter, please move the court for the court to determine whether that point of law disposes of the matter there and then. You do not have to proceed any further. Also, sorry? No. Oh, sorry. Now, I think the civil procedure rules are very helpful now. Under the old civil procedure rules, there are certain areas which were not entered. Well, there were no rules on disability, rules on mortgage, rules on other areas of the law. But let us look at another point which I want to bring to you today. And this is the question of local standard. There are many cases, especially civil cases, where the party who has originated that action has no local standard whatsoever. In other words, they are busybodies. I repeat, this was the word of Lord Leone. He said they are busybodies. There was a recent case which we all know concerning the sacking of the VP. But there was another case which was brought by the SLPP and the PMDC. That was a case where they had no local standard whatsoever. I mean, you ask yourself, what have they got to do with the sacking of the VP? But seasoned lawyers took a case like that to court. I told one of them, I said, please, you're wasting your time because, one, you are not sued in the representative capacity, which was what the first point. But the second point is, which they decided, there was no local standard. This is an internal matter between the party. What has party B and C got to do with the matter? So you have to look at it and study this question of local standard, when it applies and when it doesn't apply. Because once the party has no local standard, that is the end of the case. It is very important. And another thing you must watch is that nowadays, courts tend to give a liberal interpretation of local standard. Before, it was the restrictive attitude our courts, even our court used to use the restrictive one, which was based on the Nigerian case of Chief Adesanya versus the President of Liberia, something like that. But now we have our own law. We have lots of jurisprudence now inside. You look at some of the rare reports, Charles Mackay and others versus JSWP, Chief King and Norman, all those cases. Look at them. They were cited in previously. The question of local standard was very important. Jurisdiction, local standard. Apart from the meat of the case, these are technical areas where you can finish up the case without spending days or months. Because some people think when you spend so many days and weeks, you can charge your client millions of loans. No, I don't believe in that practice. In the end, you will not even know the law. At best, you can waste the court's time, and as my Lord said, in certain, I think it was Ivan, in certain countries, especially in England, if you want their case, you practice it. They give you time. They allocate time. If you have not done a bill, that's the end of it, until they give you another day. So please don't drag on cases which you can dispose of as early as possible if necessary. Let us now also look at those of us who will be handling some of these cases. Obviously, if you have these legal cases, you will have to see how that action has been brought, as I said. Because if you see that the action was unnecessarily brought in the wrong court, obviously you can dispose of it. Or even if it has been brought in the right court, does it disclose the cause of action? When you look at the list, there are times some of the pleadings is evidence. You must not plead evidence, you must plead facts. This is another problem we have. My brother, you see that all the time. A lot of you plead facts. You do not plead facts in your writ of summons. If it's your affidavit, yes, you can put evidence in your affidavit. But many times I look at some of the writ of summons, I think judges just don't blind eye. Because you can step it out. Because you're not supposed to insert the evidence in the writ of summons. Just the facts of the case. The evidence will come when you start to read witnesses. You have to prepare your case. If you're going to assist the person who's been in the case, you have to make sure that he's got a case that has a cause of action, that he has a case where there are witnesses to be read, and that these witnesses will lead the type of evidence which will amount to what is true. As I think it was my Lord said, or Ivan, another big fault people get in civil cases is the cross-examine when it is unnecessary. Cross-examination is not mandatory. When I teach evidence, it's not mandatory, because it is possible that when you look at the examination sheet, nothing has been said against your client, or nothing has been said that adversely affects your client. What are you cross-examining? So add more problems. In fact, if you don't have facts which have not been inserted or brought into the case by the prosecutor, you will bring it into the case by your cross-examination. Exactly. I've seen that many times. Don't try to please the audience, whether your mother is there, your colleagues, or your girlfriend is sitting, you want to please them, forget it. Don't cross-examine unless it is necessary. Also, the cross-examination should be short and sweet. Just as said, we used to prepare for that. Make sure you ask the necessary question. The even more dangerous one is the examination. If in fact, cross-examination has closed, everything is going fine, and you decide to re-examine the client or re-examine the witness when there is no necessity for it, nothing new has come out for you to clarify. My God, you're asking for trouble. It is possible that that case will go against you by your re-examination. You have to be careful. That is why when I was teaching evidence, I used to say, if you don't know evidence and you don't know procedure, you will never be a good lawyer. You will never. You can know your contract, your torts, your criminal law, your conveyancing, evidence and procedure, and the bread and butter of practice. I remember the late T.S. Johnson. I don't think any of you know him. Those were. T.S. Johnson used to say, "Oh, we not go to university, but thank God you are not against T.S. Johnson." We used to call him punch of law. Talk to Mr. Dr. Macaulay Jr., who arguably is one of the best players we have in this country, without fear, more than T.S. Johnson. He used to call him punch of law. Because when T.S. Johnson, And as I said to you, if you can turn the case around purely at the point of law, don't hesitate. Now also what I call sloppy drafting. There are times you look at the writs of summons or the defense, and the drafting can lose your case. Go over the drafting. If necessary, I am asking for second opinion. Mr. ABS is here. He's my junior. Many times I call him and say, ABS, come and look at this document. Even Jusu is there. But I'm so you are going to be a bad lawyer. No lawyer knows it all. You in fact never stop learning. You know it's my books. You might not afford, yes, that's what he said to me. He said, this is a dead body, Mr. Gavin. He said, because all the time you have excess weight, then they're giving there. I'm not saying you must get all the books, but you must get Archibald, even if the second-hand copy. You must get the white book. Without the white book, apart from your rules, because it's when you've looked at your civil rules, you look at the white book, which will help you because then you have the WILDY. It's a shop in England known for second-hand books. Please, if you give them Archibald, they'll bring for you second-hand copy of white book. So please, you can what I call the Samsumana cases. Application for an injunction. Some people quoted Order 35, some others quoted something. But if you really look at it, you have to look at Order 35. Everybody knows American Sign-a-Man. Fine to American Sign-a-Man. But there are now modifications to American Sign-a-Man. So if you look at the judgment in the injunction cases when we are dealing with that question, American Sign-a-Man does not answer. Another area I want you to look at is the state position. Or you must give 3 months notice before you issue the writ in certain cases. Or at times, even if the government wins the case against you, they have a 3-month period which they have before they execute. You have to know all of this. Also, the State Proceedings Act says you cannot issue an injunction against the government of the day. Again, that was clearly spelled out of the State Proceedings Act, but people came out with it. Yes, Section 18. These are some of the things you must have at the back of your fingertips. The moment I saw that motion on that day, I said to my colleague sitting next to me, I said, this is a joke, this one. You cannot grant an injunction. Although there has been a case, there has been a court of appeal case where an injunction has been granted. There is no doubt, I don't have it now. This was granted by a Nigerian judge who came here for a short while. Was a tournament. There is a case, in fact, Mr. Barton McCollins, but I think that case was judged on its own fact. Generally, you cannot issue, or the court will not grant an injunction against the government. Also, look at the Constitution. The immunity. You cannot bring certain people to court. You cannot bring the president, the vice president, whilst they are in office. In fact, it has been extended because although it does not include the vice president per se, in the last judgment which was given by the acting chief justice, there is now stated that that immunity also extends to the VP. So it is good for you to look at this judgment which in fact came out a couple of days ago. There was a lot of good law in it. I'm not interested in the politics. I'm interested in the law. It was good law. Those cases, as far as I was concerned, was decided on the merits. The law was good, it was clear and succinct. Another thing people don't know is interpretation. People take the Constitution, they hold it up and say, Mr. Gavin, I cannot see anywhere which says Mr. X can do this, or Mr. Y can sack somebody. No. You have now the new purposive rule. The literal rule is dead and buried. The case of Pepper versus Hart is an English case, but it now applies inside you. In fact, judges are now allowed in England to look beyond the case, that is, to look at what was debated in Parliament. Yes, this is the state that we is. But the point there is, the purposive rule is what we are now dealing with. I have looked at some of the judgments of my lord here, and this is what is applicable, not the literal rule. We used to have the literal rule, the mischief rule. No. The golden rule. Now we go for the purpose rule. Another case which I want to congratulate my guardian Georgia for was the last case in which a deputy minister was charged with a sexual offense of rape. It was interesting to me because if you know your evidence, that would have been the end of the case. And the defense lawyer, Mr. Kabakova, I'm not saying we were confined all the time, he listened. If you are charged with rape, corroboration is not required as a matter of law, but is required as a matter of practice. As I said, I missed my days when I was teaching evidence. You cannot miss it, that there is no way you can convict somebody for rape unless there is some evidence of corroboration, and the corroboration is as a matter of practice. And of course, since there is no jury, you direct yourself that in the absence of evidence, you're quite satisfied. But of course, that's another classic judgment which I think you must get hold of. The case versus Another matter I would like you to read as lawyers is the case against Paul Kamara as regards sedition. Elected lawyers, as soon as somebody goes to their chambers, they go and arrest them for libel, sedition. That's another widely abused area in this country. In fact, in England now, you cannot bring an action for libel or sedition except with the permission or approval of a judge. That is the present position in the UK. The reason for this is that these are things that can damage you for life. Many people still don't know the difference between criminal libel and sedition. In the Paul Kamara's case, Justice Mulia, who was one of the finest judges this country has ever seen, he was from, I think, Papua New Guinea, Samoa. He shared by even using Sierra cases that case was not of sedition. Criminal libel is different from sedition. There are times when what you think is criminal libel is what is known as vulgar abuse. It's not everything that is libelous. At times I just smile and say, well, I'm not there anymore. But we expect others to follow from our footsteps, because that's why we have people today who are distinguishing themselves, not because they're better than others, but because of those who are in those faculties today. That is why I always insist that it's not everybody, I'm sorry I say so, who has a business to lecture for people or has a business to teach at the hospital.
How do we address issues of social injustice? Now, quite apart from the fact that social injustice was at the heart of the root causes of our conflict, but social injustice is still present today. So how are we going to address all those issues? So that brings me to the point that the role of you people is actually a role as social and moral guarantors of peace, moral guarantors of human security, and then also making sure that people's constitutional rights are protected. So it's very, very important. And in doing that, it is but fitting to say that you really will have to make very strong impact on the individuals in society, on communities in society, and then also at the state, the level of the state in general. So how do we look at some of these advantages? Now, I see this from various perspectives. I've noted a few points. Number one, I think this process is going to contribute to all of you in making your mark in society. Making your mark in society in such a way that you are going to impact on the lives of the poor people. You're actually going to change things around for them. You're actually going to say to them that you are suffering injustice, but you are not suffering it because you are poor. We're going to ensure that your poverty does not imply that you should suffer injustice. So it means you are giving most to those very poor people. You're actually changing their lives. So that's one big advantage. The other one is that your role is going to contribute in influencing society positively. Now, when I listen to all the discussions, I have learned a lot because this is, I think, one of my second opportunity of sitting there real legal issues are being discussed. So you influence the society. When you influence the law positively, you are influencing change. Because if you have a society, if there is no law, then you have chaos. So what you people really are doing is making sure that you influence society positively in a manner that society becomes responsible and much more responsible, and we become our brother's keeper. So influencing society is good because it contributes to moral values, it contributes to social change, and it also contributes to making sure that social justices are being looked into. Now, another advantage which should be contributed to is the whole question of which I've been spoken about, developing the law itself. Developing the law itself. Now, I think Mr. Gardiner spoke about the question of case studies, jurisprudence. I think that is so important. If you don't have them, I am not sure you are in a position to develop the arts, the knowledge of the law. One other good thing which you can do is that the whole question of preparing yourself, the research I think is so important. And if you don't research very well, individually, you will not be able to make your contributions as expected. So you really need to look at research and make research your home. And this does not only apply to lawyers, it applies to every different person who are in different professions. Professionally, if you don't prepare yourself well, especially in terms of your technical knowledge, you'll be faced with quite a lot of disadvantages. Now, I think another issue I'd like to point to is the question of professionalism and ethics. I think I noted that. And I will particularly want to endorse the point about timeliness. In fact, whilst the presentations were made, I was saying to myself, can we draw an analogy with the medical case studies? Wherein, you really need to ensure that your patient is provided with medicine at the right time. And if you miss it, definitely maybe that patient is either going to die or it's going to be difficult for you to be able to address the issue. So timeliness in terms of response, I think, is very, very key. And one other aspect which has not been mentioned, I think it has to do with case management, is the use of arbitration and mediation. I know quite a lot of you people do what you call, you do settlement in chambers, dispute resolution, which is where actually conflict resolution comes in. I think it's another area which people need to be aware about, or maybe I know maybe you're doing it inadvertently. That is not all the time that you go in for litigation. There are certain times when you need to advise your client that looking at this particular case, I think it is in our both interest for us to have settlement in our chambers. I think the use of arbitration and mediation for me is extremely important. Now, the final point I would like to make is that I think we all know this old adage that there is no peace without justice. And I think it should be a watchword. Because society is looking at you, society is looking at all of us that have means with the issues of justice. That the moment you try to ensure you address the issue of justice, you are addressing the issue of peace. And that is what is very critical to peace studies. Peace studies has a lot to do in looking at what the law does in stabilizing society. So you can look at the implementation of the law, but then we are looking at the implications with regards to society, the implications with regard to stability, the implications with regards to making sure that whatever happens, the law becomes the key aspect of making sure that society is regularized. So I think those were the points which I made. I hope this particular meeting will continue, and I want to admonish all of you that this is a big challenge. Some of you are really very young. This is a place where you can be able to practice, you can be able to be the experiences, you can be able to let people know that you are around. Because it's also another way, if you do very well in your cases, it's very possible that you become so well known that people may want you to defend them in other cases. So you have to look at this process, not only as an issue of giving the free services, but then also as a way in which you're going to develop your unique talents and in a way in which society is going to appreciate you much better. So thank you.
The bottom line is your contribution. About the money you have to earn because it's a pittance, but please make sure that you stand up to the.
Thank you very much, Honorable Justice. Permit me to start. I wanted you to see, go down whosoever. But you know, criminal litigation starts from the police station, for which that the suspect, because at police station number one, arm yourself with your necessary authority and custody by the police. If you look at the Constitution, it tells not most speaking language to the police officer, and they will tell you, buddy, you know that you go to high court for any company. There was that the rape case that was that has been is all completed now. I was detained, I think, for over 10 work days, and she was on the radio. I went asked why. She said, "Oh, that is what they are required." That's when I had on the radio. Oh man, so these are some of the tips. Number two, let's go to court. This very issue.
Good morning. Could you introduce your name, your position?
I am Clerk Alton Francis, the Executive Director of the Leone Legal Aid Board.
Yeah, Madam Francis, you are organizing a training for practitioners that will be working with your organization. Yeah. What was the reason behind the training?
Well, some time ago we signed a partnership agreement with the Leone Bar Association. The lawyers themselves are partnering with us in our program in helping poor people. I am the Executive Director of the Legal Aid Board, and we are about to commence our representation of poor people before the courts of Sierra Leone. In fact, tomorrow we are going to be at the Kolopa, the criminal session of the High Court. Presently on our list, we have quite a number of cases, over 100. And we're very concerned. This is why we have partnered with the Leone Bar Association. We have signed an agreement with them. Tomorrow, hopefully, we will take on a number of representation. We will announce the Leone Legal Aid Board representation, especially for the remand prisoners at Pademba Road, and for a couple of other cases, some which are not, who are not on remand. And then we will go with the whole team of lawyers who are employed by the board. And then afterwards, we will sort out the cases to see how many of them can be handled within house, and those who are going to be given out to the lawyers. It is very, very important because Pademba Road is now getting fuller and fuller by the day. And this is one of the concerns of the board. And this is where we are appealing to friends, relatives, and everybody out there that please stay clear of the law. Do not take the law into your own hands. Avoid having matters which will take you to the police. We're there as Legal Aid Board to appear for poor people, people who are earning below the minimum wage, people who cannot afford to pay lawyers. But it doesn't mean it applies to people who deliberately take the law into their hands and ensure they break the law. It is there for people who have suffered an advantage, who are victims, who because of their poverty, they cannot have their cases before the courts. Because of their poverty, some of them are on bail, but they do not, their relatives do not even know what to do to make sure they are out of bail. Because they are on a remand, their cases are taking very long to come before the courts.
So, Madam Ansi, critics may say it is too late because we have many people that have suffered because of injustices.
Well, as the saying goes, better late than never. Sierra Leone in 2008 decided that they were going to form the Legal Aid Board, which nationally is in a lot of countries. And in 2012, the act was passed. And this year, the board has started. Our mandate covers nationwide, all those who are in police stations. So we're going to be employing paralegals and sending them to police stations. Those who have matters in court, especially dealing with human rights, violations, crime. We also have civil mandates to look at civil matters. But for the time being, the population in our correctional centers is so high that we have devoted all our resources.
So during your work, will you also during your work, will you also looking at the area of rape cases which have become so alarming in the country?
We're looking at defilement, we're looking at children and juvenile, we're looking at cases concerning women and children, men, and across the board.
So finally, so what are you, during your statement, what did you tell them, the practitioners that were already reported out to be
Well,
working
I told them, I gave them a summary of one of the matters in Pademba Road. a young boy who has been there for his life, was remanded at the age of 17, going to 18. And that boy has been there for about 4 to 5 years. His matter is yet to be heard. His grandmother comes to me on a daily basis and tells me that young man is now on suicide watch. We're so concerned. He doesn't know when his matter will end. He doesn't know when it will properly be heard, and he does not know what to do. And we want you to help. There's also the director of unit who tells me how on a daily basis they bring in prisoners who ask in which court is my case, where is my case present, at what stage is my trial, what can the lawyers do for me? And as such, for lawyers who come to court, unnecessary adjournments, unnecessary excuses, they must put themselves in the shoes of people who are remanded, of people who are behind bars. Something may have gone wrong, one way or another, and people find themselves behind bars. It will be anybody. But those people need to be given a chance to come out and be better citizens and be more useful and contribute to society.
Thank you very much. Thank you.
Good afternoon. I have 2 questions. First, I'm Daniel J. Lavalley. And I have 2 questions. Firstly, I want to know whether the legal aid board giving any form of identification to their councils, especially in representing suspects at the police station. And secondly, why is it that I am not seeing, or we are not seeing, any representation from the Sierra Leone police, especially from the Justice and Legal Service Division? Because most of what we have spoken about here is we are more concentrated on criminal matters, and it has to do with a matter which will start from the police, and we are not seeing any representation from there. Thank you.
Different groups of people. They feel a lot where the police are also involved. We even have a roundtable monthly meeting in which the AIGs and the senior police officers come. We are now planning to send paralegals to police stations. But our problem is, one, there is so much work to be done before ever that aspect of the work has to begin. And over and above that, there are a lot of setting of issues. But with the police, today is not their day. Maybe if you've been following our activities, you will see that the police are an integral part of the legal aid board. But today, the training is for practitioners. That is why we have partnered with the Bar Association. It is purely for the bar. If you look at the panelists, there are all people who, one way or another, have something to do with justice sector. And this is why we put the training together. Because we want to make sure you have as much time as possible from people with experience from the bar. There will be opportunities where we will mix you up with the police, we will mix you up with the correctional center. We already have a roundtable with them. We are looking at things from different angles. But this one really, if somebody is invited, there will be a legal aid board representation who will tell you, please call your lawyer, because you are above the threshold and above 500,000. A legal aid board will not represent you. But in this matter, the police cannot do this to you. As a board, we will take this action to make sure the police do what they're supposed to do. But please call the lawyer. Okay? Hopefully.
Activity prior to this one, illegally for Swelling Region. My only concern with regards to this one is that of continuity, because like I mentioned just now, we've had another illegally before this one, and it didn't last long, and now we're having this one also. See, my only concern is whether we have enough funds or the source of funds, and I think this question should actually go to the director of the project. See, because there's greater need for us to come out and help the indigent. But if at all we are not too sure of the continuity, that's another issue altogether.
Much of the defense before the proceedings is that it's the unavailability of witness statements. I want to ask what has been taken, what steps have been taken to ensure that voluntary incursion statements of participants have been provided to. I want to ask, why is it that the voluntary incursion statements of participants are not being made available to the defense lawyer?
Be concerned for the board on the nature of cases for which legal representation is being provided. Because judging from us here present, for instance, we are working in our private capacity as associating counsel, for example, for sexual-related offences. Do you provide legal services for such offences?
He made mention of, from time to time, calling on their practitioners to go to the police station to represent criminal suspects. My question is as to whether money will be available to those practitioners to be at least moving from one police station to another, as well as to go to the prisons and have interviews with our clients.
I want to thank all of you very much and to say first and foremost, what existed before the legal aid law was a pilot national legal aid project. It was there for a particular period, for it, the whole project to be piloted, for everybody to see success. And then at a certain stage, about a year and a half to the second year, the board came into existence. Okay? So the board is by an act of parliament, it's a permanent institution. One of the key challenges of the board is fundraising to both governments and donors. But as we are now, we are doing our level best to ensure that whatever little funds you get, the primary objective is to devote it to ensuring we have counsel. Definitely.
It's been awarded certificate in recognition of the one-day training for counsel willing to be assigned to indigent suspects, accused persons, and convicts appearing before the court of Sierra Leone. It was duly signed by the director of the legal aid board alongside the president of the Second Empire State Show. So Mr. Abraman Bangura Esquire has been awarded Tamara. So the norm is we bow. I think you just sham. Now we just call the names. Next in line is Mr. Ibrahim Kane. Mr. Francis K. Gabra. Mr. Joel Tijan Dean Terry. Mr. Augustine Musa. Mr. Prince B. Wilson. Sorry, Williams. Miss Christina Davis Cole. Mr. Tijan Lejer. Mr. Tijan Lejer. Mr. Afasa Indole.
one goes to Star Radio and Television. Let us give them a big hand as one of the real true service providers for legal aid for Sierra Leone. The Sierra Leone Broadcasting Corporation. Please give to the Director General. Thank you. Concord Times newspaper. African Young Voices. AYV. The Q Restaurant. Let's clap for them. Where's the president of Q Restaurant? The manager. Thank you. For the Sierra Leone Bar Association, we are recognizing Miss Precious Fury, our tireless efforts in working with the bar and always in our policies. And no less a person than the president of the bar, Mr. Ibrahim Sow. We have our office staff. They are always at the secretariat. Can we get them in here, please?